Welcome to everyone on 2/22/22. I don't have a corny joke for you other than to point out that it's palindrome every day this week. So welcome. We have another full program for you today. Leading us off is going to be Hannah Redmond. Hannah is an attorney in our Syracuse office in the Labor and Employment Department. Hannah is going to discuss with us some recent changes in particular the whistleblower protection statute within the labor law. So Hannah, please take it away.
Thanks, Adam, and hello, everybody. I think it's fitting that I'm on this week's webinar, given that my first name is a palindrome. So today we're going to talk updates to the whistleblower law changes under New York State's labor law, section 40, where the whistleblower protections are codified. This law, section 740, was recently amended and the amendments became effective January 26th, 2022. So we thought an update would be helpful to everyone to remind everyone of what these changes are. Section 740 is not new, but its scope and protections against disclosure of an employer's illegal or improper actions have now been expanded. So I don't know about all of you, but I love a good before and after. Show me a kitchen renovation, a makeover, I'm here for it. So I thought it would be fun to do a before and after of the changes to section 740. I will confess that when we're talking legislative amendments, a before and after is a little bit less fun and dramatic, but it's important nonetheless. So let's get started. So first, who is protected? Before the amendments to section 740, employees were protected. And the statute talked in the active voice, meaning employees who were on the payroll, who were under the control and direction of their employer. Now, after the amendments, employees continue to be protected, but former employees and independent contractors are also covered. So this is a significant expansion. Former employees are protected, and most notably independent contractors. So people we typically would exclude from employee protections are getting protections under 740 now. Next slide, please. What is protected activity? Before the amendments, section 740 protected employees who reported employer activity that violated a law when the violation posed a danger to the public health or safety or which constituted healthcare fraud. So there were two parts. There had to be a violation of the law, and that violation had to pose a danger to public health and safety or constitute healthcare fraud. And not only did the employee have to, it wasn't enough that the employee believed that there was a violation. The employee was required to prove an employer's violation of a law. That is no longer the case. So after the amendments, section 740 protects employees who report employer activity that is reasonably believed to violate any law. Section 740 also protects employees who report employer activity that is reasonably believed to pose a danger to public health or safety. So you no longer need both, and any law, a violation of any law, whether or not that violation poses a danger to public health or safety or constitutes a healthcare fraud, is protected. And most notably, employees only need to reasonably believe that their employer is in violation of the law. They don't need to prove an actual violation. So we know that an employee is protected when they report or disclose an employer's violation of law. So it becomes important to understand what is a law, rule, or regulation, and that's the three words that the statute uses. Before the amendments, a law, I'm going to just broadly talk about these, about laws, rules, and regulations as laws. Laws included statutes, ordinances, rules, and regulations, not groundbreaking. These are the things we typically think about when we think about laws. After the amendments, statutes, ordinances, rules, and regulations continue to be considered a law, but executive orders were added to that list, as were judicial and administrative decisions, rulings, and orders. So again, we're seeing an expansion of the protections, and an employer who reports a violation of something like an executive order would also get protection under 740. And there's some speculation that that's the result of all of the COVID executive orders. So what is retaliatory action? Before the amendments, retaliatory action was retaliatory personnel action. So it was discharge, suspension, demotion, and other things that we typically think about as adverse employment actions. If you're thinking about adverse employment actions in the discrimination and retaliation context, there's those kinds of actions. After the amendments, the word personnel was struck from the statute. So now we're just talking about retaliatory actions, and this is likely a response to the expansion of the definition of employee to cover former employees and independent contractors who we don't traditionally think of as personnel. Discharge, suspension, and demotion, plus those other traditional adverse employment actions, continue to be considered retaliatory action. But we have a few additional categories, such as threatening, penalizing, and discriminating against employees for exercising their rights under Section 740, taking or threatening to take action to impact current or future employment, things like blacklisting an employee or threatening to blacklist an employee in the industry. And then finally, threatening to report the employee or their employee's family member or household member, their immigration status to authorities. So again, seeing significant expansions. Employer notification. This is a really important slide. Before the amendments, a defense that employers often relied upon was that their employee did not notify them of the alleged violation. So before the amendments, employees were required to notify their employer of an alleged violation before they took it public, before they reported the violation to a public body. This is no longer the case. Employees now only need to make a good faith effort to report an alleged violation to their employer before going to the authorities or a public body. So we're seeing this exception, or the employer notification, watered down significantly, and an employee does not need to make a good faith effort in several circumstances as well. So we no longer need an actual notification. We only need a good faith effort to make a notification, and the notification requirement is accepted when there's an imminent danger to public health or safety, or when the employee reasonably believes reporting would result in concealment or destruction of evidence, when the employee reasonably believes reporting would endanger the welfare of a minor or result in physical harm to the employee or another person, or where the employee reasonably believes the employer is already aware of the violation and will not correct it. So under any 5 of those circumstances, there's not even an obligation to make a good faith effort to report a violation to the employer before going to a public body. The statute of limitations used to be 1 year. It's now been doubled. So it's 2 years. Employees have 2 years to report an alleged violation. Damages. Before the amendments, there were several categories of damages available to employees, including injunctive relief, reinstatement, back pay for lost wages and benefits, and attorney's fees and costs. All of those categories of damages remain available. However, now employees may be entitled to front pay in lieu of reinstatement. Civil penalties can be assessed against employers for up to $10,000. And in certain cases, punitive damages may be available, but there'll need to be proof that the violation was willful, malicious, or wanton. And I'll note too that employers under the amended statute are still able to recover attorney's fees and costs if it's shown that the employee's allegations lacked factual or legal merit. And that's not a change, but just a good note for everyone. Additional changes that didn't fit nicely into my before and after charts. Jury trials are available, and there is a publication requirement. So employers are required to inform their employees of their rights under this section by posting a notice that has been disseminated by the New York State Department of Labor. The notice must be placed in a conspicuous place that's easily accessible and is regularly accessed and frequented by employees and applicants. The notice was recently published by the Department of Labor, and it is linked here. I will throw that link in the chat as soon as I'm done talking, which will be in just a moment. But that is an overview of the before and after for Section 740 whistleblower protections for employees. If you have any questions, as always, feel free to reach out.
Hannah, thank you. That was great. Very easy to understand. I can't emphasize enough how important these changes are. We represent a lot of employers who get sued by their employees claiming an alleged violation of Section 740. And one of the primary defenses that we've had available to us for the life of the statute is that there wasn't an actual violation of law or regulation. It's gone. So now employees can bring a claim under Section 740, even if there isn't an actual violation. So I'll give you an example as it relates to COVID regulations, the HERO Act that we're going to be talking about in a little bit. If an employee raises a claim that you as the employer are violating the HERO Act, the safety provisions within the HERO Act, whether you are or not, if they reasonably believe it, that might or that could entitle them to relief under Section 740. So this is a big change. And it's something that all employers should be aware of. Okay, so moving on, we're going to bring back Pete Jones. Pete has obviously been on this webinar many times, although he told me today he was itching to present because he hadn't been on in quite some time. So today, Pete's here to talk about the healthcare vaccine mandate and the most recent updates related to that. So Pete, the floor is yours.
Thank you, Adam, and it's good to be back here with everybody. If I adopt Hannah's before and after, I don't have a chart to that effect, but I kind of like the the juxtaposition here. Before February 18th, there was a booster mandate for healthcare employers in New York State, and after February 18th, there is not. It was scheduled to go into effect February 21st, and on Friday, the Friday before, the state put out an announcement indicating that they were, at a minimum, going to postpone the booster mandate. And the statement, said explicitly that in order to avoid potential staffing issues and also to give healthcare workers more time to get boosted, the state would not enforce the requirement that was scheduled to go into effect on February 21. Further, they said that they would reassess in 3 months whether there's any additional steps that need to be taken to increase booster rates among healthcare workers. And they noted that the original vaccination requirement for healthcare workers remains in effect. That is the requirement that that workers receive an initial series, either the one shot from J&J or 2 from Pfizer or Moderna, remains in effect. So the short headline here is that this avoided an issue that was looming in New York State. And I think there were a lot of healthcare providers who were very concerned that they were not going to be able to staff their operations. So
Pete, you just muted yourself.
thank you. Just trying to move to the next slide. I managed to commit a rookie mistake here. So the state did, and I thought this was interesting, the state put some data out in conjunction with this, I think to explain themselves and perhaps also to indicate why they had reversed course here. And I'm reproducing the data here in this slide and in the next, but the way they reported this was the number of individual employees who had already received the booster and those who were willing and or awaiting the booster, creating a percentage of total staff number. And I think the thinking was that those percentage numbers were fairly high. The interesting thing, though, if you go a little bit beyond the data, is for instance, in the hospital line, we see 278,000, almost 280,000 who had received the booster, and another approximately 155,000 who had not. The total is 84%, but obviously those who had not received the booster were a significant number. And if we look at the nursing home situation, we see that those numbers are in fact even worse. So some interesting data there in terms of who would be willing to receive the booster. Next slide is just some additional data that breaks it down a little bit further by industry. In the direct care staff, 88% of hospital direct care staff, only 51% of nursing homes. So I think you see there that those numbers probably were insurmountable for the Department of Health when they were trying to figure out what to do next year. Okay, So with that in mind, let's go back and just sort of remind everybody of where we were. I don't want to belabor this too much in depth, but for those of you who lived through it, the emergency regulations were originally posted back in, or issued back in August of 2021. And that's where the initial vaccination requirement went into effect. You'll all recall that there was some court proceedings, an initial TRO, followed by an extension of the TRO, and ultimately the Second Circuit Court of Appeals vacated the stay. And the issue here really was the religious exemption. And ultimately, after the Second Circuit decision, we go forward with no religious exemption for the vaccine mandate. So the nuts and bolts of the vaccine mandate that remains in effect, the initial mandate, there is no test out option. There is a medical exemption. There is no religious exemption. And it's very broad in terms of the covered personnel. Anybody who's in contact such that they could expose other covered personnel, patients, residents, or staff to COVID. So really very, very broad there. When we look at the emergency medical exemptions, they were fairly narrow, had to be tailored to generally acceptable medical standards. The possibility of severe allergic reaction to a previous dose or to the components would be a justification, and some other limited precautions were listed. The precautions indicating that probably further medical analysis would be needed in order to assess whether a medical exemption is appropriate. And the exempt individuals were allowed to continue to perform their jobs. And so that did not require testing and did not require that they not perform the jobs if a medical exemption were applicable. On the other hand, the emergency regulations did not contain that religious exemption, and that would be triggered by a sincerely held religious belief in most contexts, but not included in the regulations in this context. There has been discussion both at the EOC level and also at the Department of Health in their FAQs about what obligations an employer does have to engage in reasonable accommodation discussions. There's an FAQ that indicates that the employer does have that obligation, but it's also, I think, equally clear that these folks cannot work in person as an accommodation. And so then you're left with the notion that you might put somebody on leave, or they might be able to work remotely, but in-person work on a religious exemption does not appear to be contemplated by the regulations. I do think there's a little bit of a trap in here, potentially for employers who say, because you can't work in person and your job involves in-person work, we're going to deny your request. I think a better approach is to process that request and work through and reach the conclusion either that leave is inappropriate and or remote work is unavailable, and therefore you're unable to accommodate because it's an undue hardship to let them work in person. That's a bit of a nuance, but it's probably the stronger way to proceed in terms of protecting yourself legally. So that's the brief summary here. I mean, the headline again is that the booster has been put on hold. Worth reminding people of the underlying requirements. There may be some lessons here possibly too for other industries and for employers who are not subject to mandates, but I suppose time will tell on that, Adam. I'm not sure exactly what this means, other than there was such resistance that the state felt they had to put it on hold for a while.
I think that's a really good point, Pete. For any of you non-healthcare employers who aren't subject to this requirement, to the extent you have a vaccine mandate, and to the extent you're thinking about implementing a booster mandate as well, this may not be a good sign for you in terms of employee participation. I know that many of you who have vaccine mandates in place encountered resistance when you first put them in place. the level of resistance for boosters may be even more significant if this is any indication. So thank you, Pete, for that. Very good update. Next, we have institution clients.
Thanks, Adam. Welcome, everybody. So I'm Kyle Skillman. I'm a member with Bond, Schoeneck King. My colleague, Kyle Ritchie, also on the call here. The primary focus of our collegiate sports group is to work with higher ed institutions on NCAA related issues. Right now, there are some significant issues, or at least perceived significant issues concerning name, image, and likeness rights that have been given to student athletes at higher ed institutions in athletics. We've been working with a lot of institutions on what that means for the institutions, what it means for the student athletes, and the way that the NCAA has been applying its rules to this kind of new world for athletics. Kyle Ritchie has been spearheading those efforts with us in terms of the way that the state laws apply, the way that the NCAA's interim policy applies, and then on institutional policies that apply to name, image, and likeness. He's going to walk you through that a little bit today, and then I'll pick up on some of the current NCAA enforcement actions that are happening kind of nationwide on name, image, and likeness. Go ahead, Kyle.
Thanks, Kyle. Again, my name's Kyle Ritchie, and I've been leading this office's kind of the research and trying to keep up to date on everything that's been going on with name, image, and likeness. And so what we're seeing, just by way of background, just to give you a kind of an understanding of what name, image, and likeness is. So it used to be the idea of a student athlete, being able to advertise for a car dealer, for somebody. Basically, I'm going to come out, I'm going to give autographs. The literal definition of name, image, and likeness. That's obviously that has evolved as time has gone on, and now there's certainly a big space within social media. Having influencers there. There's also obviously monetary compensation that can come out of that. And so the first to understand, one, that's what name, image, and likeness is. The second, the second part is to understand what the NCAA and what collegiate athletics looked like before July 1st of 2021, which is that is when the NCAA interim policy went into effect. And so the NCAA has been around for over 100 years. And one of the founding principles that's in the Constitution for the NCAA is this concept of amateurism. Amateurism, being the idea that you're not going to get paid compensation for your participation in your collegiate sports. And what that's looked like over the years is that there are situations where you could be a regular student who's not a student athlete and can benefit off of a situation like name, image, and likeness. And then obviously a student athlete can't turn around and do the same thing and get paid for it. So that's kind of been the basic rule that had been in play, for like I said, for over 100 years. But as time has moved on, and as you may be aware, there have been legal challenges to that idea of amateurism and what the NCAA can control. Starting in the mid 90s with the O'Bannon case and really moving along all the way to the Alston case, which was decided in June, just before this name, image, likeness interim policy went into effect. You could see the ball was really rolling towards some sort of compensation model for a student athlete. Now, it's important to understand that, again, this concept of amateurism has been obviously part of the Constitution for the NCAA. It's also It's also codified in bylaw 12 of the NCAA enforcement in the bylaws, which is what, essentially when the NCAA enforcement staff would hear or find out about, a potential violation or a potential situation going on. A lot of times those amateurism rules would be the ones cited as, throughout the investigation and then eventually the hearing process. What began to happen as early as 2019 with the state of California, and then with great regularity and a lot of times very fast-paced bills. Last year, right before July 1st, when it appeared that these first couple states, including Florida and California, were going to pass these name, image, likeness laws that would then allow, according to state law, student athletes to be compensated for these types of services or licenses, which would then obviously put the NCAA's policy in direct contradiction to the state law, leading to additional litigation. It became clear that the NCAA was going to do something related to name, image, and likeness. To what extent that would be was up in the air even until the last week or so of June 2021. And while that was going on, north of 20 states passed their own specific NCAA or their own specific name, image, likeness laws, going into effect anywhere from July 1st, 2021 to we've seen a number of states that have laws that don't go into effect for 3-4 years from now. On July 1st, the NCAA releases the NCAA interim policy on name, image, and likeness, which basically it sets forth 4 pillars. It asks a question about institutional involvement, but before that, it tries to answer the question of what happens with an NCAA policy in a state that either has a name, image, likeness policy that is on the books and in effect, and obviously then we've also got states that do not have a name, image, likeness policy. Basically, so the NCAA has taken the position that they will not interpret state law and being able to abide by the terms of the state law. That's not their prerogative. If there is a state law, if part of the state name, image, likeness law directly addresses the same issue that the NCAA interim policy addresses, the state law will govern. If the state law is silent on a similar issue, then the NCAA interim policy would then cover that portion. Obviously, in a state without a name, image, likeness law in the books, the basic NCAA interim policy is what governs. So to understand the interim policy, it's very there's not a lot to it. There's 4 rules that student athletes have to follow. 4 rules that the people who are the third parties who are contracting with the student athletes have to follow, and then really a question of institutional involvement and to what level that's allowed under the policy. So the first of these 4 pillars, the first is there's a requirement of quid pro quo, meaning the student athlete has to actually perform services in exchange for the money that is or the compensation that is paid to the student athlete. And so and what guidance we've received from the NCAA is that the services, it's better off in whatever agreement is set forth. It's better off that those actual services are listed. It makes it easier. It makes it easier, 1, to prove, and 2, to follow up, just to figure out if the quid pro quo has been provided or is being provided. We've seen some issues with advance payments. We've seen some issues with delayed work contemplated in contracts. As we get in a couple minutes, we'll get to the point of this idea of third parties and what their goals are. But from the quid pro quo standpoint, obviously there's a number of potential business and contract issues in how you structure these deals. But again, services being provided is something that's required. The second part is that the compensation or the name, image, likeness deal cannot be a recruiting inducement. It can't be conditioned on attending a certain institution or continuing your enrollment at a certain institution. If you're aware of both football and basketball and all sports really, but there's this idea of the transfer portal that has been a new issue that's been, we've had to face in the last year or so. And so the idea of if somebody enters the transfer portal, in theory, they become a recruit again or a prospective student athlete. So again, various NCAA rules will apply to them. But so where the NIL law goes is, hey, you can't tell a kid that hey, we'll give you $100,000 so long as you attend X university. That in itself, by the language of the policy, would be against the policy. The third is there can't be pay for performance. And pay for performance is both the way I think a lot of people think about it. And hey, if you go throw 3 touchdowns, or hit certain goals throughout the season, we'll give you X amount of money. That's not allowed. Also, in the pay for play, pay for participation idea comes out, in that you're requiring, in order to provide name, image, likeness services, you're requiring that they be a student athlete or they participate in a specific sport at that institution, or you can leave that out in the contract, but again, requiring you to be a collegiate football player. That in itself is again, you're conditioning the contract on something that the NCAA is not allowing. And then the last portion, the fourth pillar, the last pillar, is that the money or the compensation paid to the student athlete has to be fair market value. Now, that's probably the hardest one that the NCAA, when they decide to try and enforce some of this policy, fair market value, determining what that is, certainly would prove difficult and may end up facing legal challenges. Just with the idea that the market dictates what fair market value is. But there's going to be some interesting arguments, and then obviously there's different situations that may compare very similar exposures on social media, and looking at the amount of money that's being paid to 2 different people with different exposures. In theory, you could create some arguments, but it remains to be seen where that's going to end up. The next part, and this is for our higher education clients. This has been a question that we have not, this is where a lot of our guidance has been at this point. And the question really becomes, how involved should an institution be in the name, image, likeness space? And what we saw right away in July was institutions trying to come up with what their name, image, likeness policy should be, what it should look like, what they should require from student athletes. So some of the basics being, we need to have some sort of disclosure system so that we're at least aware of the contracts that are coming in, and some way to at least review the basic details of these contracts, so that we can ensure that we're not in violation of these core NCAA rules. While name, image, likeness and the interim policy suspended parts of bylaw 12 as far as the amateurism point, the idea of institutional control and monitoring are still certainly in effect, and violations of other NCAA rules like extra benefits or recruiting inducements, those specifically and expressly are still in place. So with that in mind, the idea of institutional involvement in this, we need to come up with an NIL policy so that we can comply with the remaining NCAA rules. And then we've got to figure out, what's best for the institution. There are some basic NCAA language that we would counsel our clients on as far as being able to protect yourselves and put yourself in a discretion-based policy. So there's not an NCAA violation if something isn't followed to the letter of the law as far as how the policy plays out. But also, there's also a lot of questions that higher education institutions have to look at, and that's, do you want your trademarks, your IP to be used by student athletes? And if so, what process do you want that to look like? What approval rights do you want? Or is it just a blanket no? So that's an example of some of these issues that have come up. Where on campus would you allow name, image, likeness activities to take place, if anywhere? Again, it's just trying to put your student athletes in a position to obviously be able to take advantage of the name, image, likeness policy. But on the flip side, you don't want to be in a situation where the only way to stop what a student athlete's doing is to send a cease and desist letter to your starting quarterback. That's not certainly not something anybody's general counsel's office is going to want to do. So, like I said, the first part of really what we got into is help, drafting these NIL policies. And then, as time has gone on, we've started to see, some of the other issues that come into this, and institutional involvement is a big one. I'm going to put in the chat right now, or I guess, to everyone. I'm going to put in the chat right now. This is the NCAA's question and answer for the name, image, likeness policy. And one big issue as we talk about institutional involvement is number 8. And the idea is, are institutions permitted to arrange NIL opportunities for student athletes? The NCAA hasn't said one way or another whether you can or you can't. As Kyle's going to talk about with enforcement here in a little bit, there are situations where it appears that they are allowed to be involved to some extent, but there's a line out there that, while it hasn't been defined yet, is certainly where we're looking. So, and just to move on again here, Kyle, here real quick. This idea that there's a position where the institutions can be involved. Our job is to help counsel the institution, take a risk assessment of where the institution wants to go, what they're willing to, how risk averse are they based upon NCAA enforcement, and how can we help them both at this moment, 7-8 months into the NIL land space, or as we go 4 months down the line and the rules continue to change, or we continue to see enforcement move a certain direction. What can we do again to help position our clients to be able to serve their student athletes the best they can? Kyle?
Yeah, and just real quick. So with the public attention that's being paid to some of these deals, some of which are 7 figures in nature, and they're getting published pretty quickly, particularly on the coast. A lot of people are wondering what the NCAA is doing about it to try and rein it back in. And again, just very briefly, the NCAA enforcement staff is sending letters to institutions requesting information about particular deals. They're requesting the contracts. They're requesting the nature of the communications between athletics staff and the third-party entities that are offering the deals to the student athletes. And they aren't just to educate themselves. They're truly trying to determine how and when and if the NCAA rules apply to try and reel some of this back in. So that's happening. It may not be public facing, but it is on the back end, and we're working with a number of institutions to respond to those requests. So
Well, Kyle, thank you so much. That is an incredibly detailed topic. And I will say this for our higher education clients that are on, we will be doing a focused webinar on NIL issues that Kyle will be participating on. 20 minutes is unfortunately not enough time for them to really cover what they need to cover. So thank you, Kyle. We really appreciate your time. Okay, now the last thing we're going to talk about is the HERO Act. We received quite a few questions during last week's webinar about the HERO Act, what's going on with the HERO Act. So I thought it would be a good time to kind of take a step back, look at what the HERO Act requires and where we are with it. So next slide, Kathy. Okay, so just by way of review, what is the HERO Act? It's the airborne infectious disease. It requires airborne infectious disease exposure prevention plans. It became effective on July 4th, and it applies to all private employers, no numerosity threshold. There's also the workplace safety committee requirement in the HERO Act. I'm not going to talk about that today. Next slide, please. So who is covered by the HERO Act? Only applies to private employers, covers a wide range of workers, not just formal employees, and it only applies to airborne infectious agents or diseases as designated by the New York State Commissioner of Health. The standard is clear that it doesn't apply to seasonal or endemic infectious agents like the flu. This becomes important as we go into the next stage of the pandemic and whether or not COVID is declared to be an endemic rather than a pandemic. It also doesn't apply to any employee who's subject to a temporary or permanent standard promulgated by OSHA. Next slide. So the two documents that are relevant for the HERO Act are linked here. It's the Prevent Airborne Infectious Disease Exposure Prevention Standard. So that sets out the standards and requirements. And then there's a general model plan, which I've linked here, and more specific model plans depending on industry. The state provides these model plans, and they are typically a good resource and where most of our clients have ended up. They've, for the most part, used the model plans. Next slide. So the specific topics that have to be covered in your HERO Act plan include health screenings, face coverings, which we're going to talk about in just a second, PPE, among other things. I'm not going to read through these. You can read through them, and you will have the slides available to you as well. So these are the topics that are generally covered or have to be covered in your HERO Act plan. Next slide, please. So what happened on February 9th was we had the governor issue a declaration as it relates to the statewide mask mandate, which doesn't apply to the HERO Act. And then we had the HERO Act model plan be updated the next day. And rather than providing a clear explanation of exactly what the mask mandate update is for the HERO Act, this is the paragraph that the model plan now includes. Next slide. Rather than read it to you, here are one more further, Kathy, please. Rather than read it to you, here are our impressions of what it means. Next slide. It indicates that the state is not requiring employers to mandate employees to wear masks unless the setting is specifically referenced in the model plan language. So within that paragraph, there were specific where masking was required. High risk settings, including schools, healthcare certain healthcare settings, public transportation, etc. Also, it's important to note that this new model plan language recommends but does not require masking for unvaccinated individuals at work. And here I want to point out the difference between the general mask mandate that the governor eliminated for the most part and the HERO Act. So the general mask mandate would apply to anyone, would apply to employees, it would apply to visitors, it would apply to consumers. That's gone. We know the general mask mandate is gone. However, the HERO Act remains, but what we now know is that the HERO Act also is not going to require employers to have their employees wear masks unless you are in one of these specified settings. So this was a significant change to the model plan that just came out last week. Next slide. So additional requirements for the HERO Act, there's a written notice and posting requirement. There's a training requirement. Hopefully you all followed these requirements last year, but just in case you're wondering, here they are. Next slide, please. Next, I think the most important thing I'm going to say during my little presentation here is that the designation by the Commissioner of Health, which activates your HERO Act plans, was extended again, and now the new control date is March 17th. So the most recent extension was from February 15th to March 17th. So all of the HERO Act plan safety protocols you have in place, including health screening, daily health screening, have to be complied with at least through March 17th. What the state will do past that date, we don't know. The state has been evaluating the HERO Act designation on a monthly basis, 30-day extensions since the designation first expired. Right now, it's been extended through March 17th, and we'll certainly provide you with an update after March 17th. Next slide, please. So just by way of some additional information, here is what the standard says you have to do once the designation is made. I'm sure all of you have done this, but again, just for your reference, there is a list of things that you're supposed to have done. Next slide. And here is what you should be doing while the designation continues in effect. You should make sure you have enforcement responsibilities assigned to somebody. You have to monitor and maintain your exposure controls, follow updates to the guidance like the one we just talked about, and designate one or more supervisory employees to comply with the plan. And the standard is pretty clear. It has to be a supervisory employee. Next slide. So review your plan, update it as necessary. Remember, these HERO Act plans gave employers a lot of leeway. You could select from a number of options related to safety protocols. Review it, make sure it still makes sense. You still fall within the requirements of the standard. Be prepared to update or change your plan when things happen like they did last week. Make sure you have provided that verbal training. It's only required once to employees, and provide updated copies when you make changes. Next slide. Here is what the verbal review and training was supposed to include. I'm not going to go through all that, but again, it's there for your reference. Next slide. Okay, so that is it for today. Thank you all for being with us. We hope to see you again next week. I'm sure there will be some new developments that we will be covering. Have a great Tuesday. Take care.